should you take your claim to court? It's no secret that patent litigation is a lengthy process, from finding documents and reviewing pleadings to appearing for depositions and other pretrial proceedings. Enforcing a patent requires a lot of time and attention from the patent owner. It may take 2 to 4 years before a case even goes to trial, and then post-trial proceedings can take another 6 months to a year. And it doesn't end there. Appeals can add on another several years before the lawsuit is finished. On the positive side, successful patentees can reap huge monetary damages for another's patent infringement, including lost profits and, in exceptional cases, enhanced treble damages if the infringement is deemed willful, as well as an award of the patentee's attorney's fees. If a patent holder asserts a patent against a competitor, he or she can also obtain a judicial order barring the competitor from continuing to infringe the patent. Although this is rare, it can reap huge additional rewards measured in increased market share and pricing power. Patents not only offer patentees the opportunity to play offense in the marketplace, but also provide a very potent defense against charges of infringement by others. Competitors are often wary of attacking businesses with extensive patent portfolios. Once a decision is made to enforce a patent via litigation, a complex series of steps begins that determine the who, what, where, when, and how of events that will unfold. Who. The first step is deciding who to sue. If the infringer is a corporation, you can sue it. If the company is closely held or dominated by a single shareholder, you can sue those individuals. If the infringer has subsidiaries, you must choose which of them to include as defendants. Any person or entity that violates one of these exclusive rights is a potential defendant. What? If you have more than one patent, you'll need to determine which have been infringed. Courts now routinely require that you provide details about which patent claims are being asserted against which product or service. You will also be required to provide a claim chart that details those assertions precisely. Where? If your defendant is a private party, the proper location or venue for the case is the federal district court in the geographic location where the defendant is incorporated or resides, or where the claim arose. Determining a company's state of incorporation is a matter of public record, as are the locations of its facilities. The place where the claim arose includes anywhere the infringing product or service is made, sold, offered, used, or imported. Products or services with enough sales to justify a patent infringement lawsuit are typically available nationwide, opening up virtually any federal court as a possible venue. When? Absent any other constraints or objectives, lawsuits should be filed as soon after the infringing activity is discovered as possible, given the need to investigate and prepare before filing a complaint. Another issue you face is whether to notify the alleged infringer before filing suit. Bringing the infringement up prior to filing a lawsuit and requesting that infringement stops may seem logical. However, it may cause additional pitfalls along the way. Accusing someone of infringement allows them to sue you preemptively, asking the court for a quick decision that no infringement exists. This type of judicial decision is called a declaratory judgment of non-infringement. Yielding to your opponent's strategic advantages, such as the choice of forum and the element of surprise, may cost you in the end. A middle ground does exist. One avenue to consider is filing the lawsuit simultaneously with or immediately after, making a demand that the infringer stop the infringing activities. You can defer formally serving the lawsuit on your opponent for as long as 90 days in some courts. This advantage allows you to negotiate with your opponent from a position of strength and with your choice of forum firmly established without appearing unreasonable. How? Once you choose to file suit, the how is largely dictated by the federal rules of civil procedure, the federal rules of evidence, and the local rules of the chosen venue. One important decision remains: judge or jury. Until the 1990s, almost all patent cases were tried to a judge because they were thought to be too complex for juries. But then, some enterprising plaintiffs' lawyers decided to request that a jury decide their case, perhaps seeking to take advantage of the complexity of the cases and the belief that juries trust patents because they are issued by the federal government after examination by USPTO experts. That has led to the current reality, which is that almost all patent cases filed now request a jury trial. Interestingly, statistics show that this trend of requesting a jury does not always benefit plaintiffs. Depending on the venue, plaintiffs only win 60 to 75% of the time, despite having the advantage of being able to pick what cases they file and where they file them. Of course, the outcome of a particular case depends on a myriad of factors unique to that case. No party can be assured victory when a jury is involved.